Appearance? Yes.
May the call be please, sir. My name is Kayode Ashade. My humble appearance is for the defendant, sir.
Mr. Kayode, wait. The claimant has not announced his appearance. The counsel for the counsel for the claimant is in court physically. So let me record the claimant.
Sir. I'm grateful, sir.
Yes. Yes. Igwe Chidima. For the claimant, holding brief of Yes, Mr. Kayode.
My name is Kayode Ashade. My humble appearance is for the defendants.
Yes, this matter is for judgment. The judgment is going to be read now. This is the judgment of the court. By the general form of complaint accompanied by statement of facts and other front-loaded processes filed on the 6th day of January 2021, the claimant commenced this instant suit seeking against the defendant the relief stated as follows. I have reproduced the relief, so I will skip reading them. Upon being served with the general form of complaint, the defendants on their part filed joint statement of defense and accompanying the process and accompanying processes dated 29th day of March 2021. The claimant filed a reply to the statement of defense and further written statement on oath, both dated 4th day of October 2021. The claimant testified in proof of her case as CW1. She also tendered some document in evidence which were marked as exhibit. At the conclusion of the examination in chief, CW1 was cross-examined by counsel for the defendants. There was no examination thereafter. The CW1 was discharged and the claimant case was closed. The defendant called one Cynthia Ogbonna, the second defendant in this case, who testified as DW1. DW1, after identifying her witness statement on oath of 19th day of June 2021, adopted same as evidence of the defendant in the defense of the case. 7 documents were tendered and admitted in evidence. The documents were marked as D1 to D7. Upon conclusion of our examination in chief, DW1 was cross-examined by the counsel for the claimant. Thereafter, she was discharged. The submissions, I have given a summary of the facts, so I will skip reading that one. The submission of the defendant formulated a single issue for determination. That is to say whether having regard to the totality of evidence as on the record before this honorable court, the claimant has proved her case against the first and second defendant jointly and severally to be entitled to relief sought therein. The argument on the issue has been captured in the body of the judgment, so I will skip reading the argument which has been reproduced. When counsel got the hard copy, they will be able to read the submissions. Then I go to the submission of the claimant. The claimant formulated 3 issues for determination. They are: 1, whether the facts and circumstances of this case and the evidence or record, the claimant prove her case founded or wrongful termination. 2, whether having regard to the facts and circumstances of this case and the evidence or record, the claimant fundamental right as enshrined in section 34 and 42 of the Constitution of the Federal Republic of Nigeria 1999 as amended was breached in the course of her employment. 3, whether the claimant is entitled to the relief sought having regard to the evidence or record. The argument on all the issues have been captured in the body of the argument. So I will, in the body of the judgment. So I will keep reading the submission based on the issues formulated, the 3 issues. I now go to the I will go to the decision of the court. I will go to the decision of the court. I have carefully and painstakingly considered the processes filed in this suit, the evidence laid by the parties, as well as the written and oral submissions of counsel for both parties. The gist of the facts on which this suit is being fought are straightforward and not much in dispute. The claimant was employed by the first defendant and her employment was confirmed and got promotion to the post of 2IC second in command. This was as a result of her performance during the test conducted for that purpose. However, the claimant was accused of violating the first defendant rules and procedure regarding TIL. Consequently, a disciplinary committee was set up under the chairmanship of the second defendant to look into the allegations leveled against the claimant. The claimant appeared before the disciplinary committee's hearing, at the end of which the claimant was found guilty as charged. The claimant lodged an appeal against the verdict of the disciplinary committee. The appeal was not successful as the verdict of termination of the claimant's employment was returned and upheld by the appeal panel. The claimant approached this court to challenge the propriety of termination of her appointment on the ground that the entire disciplinary hearing and the appeal hearing were in violation of the first defendant policy on fair hearing, and her rights as enshrined in the Constitution were violated. I have extensively examined the argument of counsel for the parties in their respective final written addresses and reply on point of law. The law is right that where an employee asserts wrongful termination of his employment, he is duty bound to establish that he is an employee of the defendant, prove the terms and conditions of service, as the condition of service is sine qua non for the court to be able to determine the appropriateness or otherwise of the termination or right of the parties under the contract. The employee must also establish how the defendant breached the terms and conditions of service. See the case of Amodu versus Amude. See also UBA versus Ogbo. See also UBN versus Soligi. In the case at hand, the parties are at idem that the claimant was employed by the first defendant and his employment was terminated. However, parties are not agreed on the terms and conditions of service. The claimant is insisting that the terms and conditions of his service are as contained in the policy guide of the defendant, which had never been made available to her, as the first defendant has refused to make it available to his employees, including the claimant. For the defendants, the terms and conditions of service are as contained in the claimant's letter of employment, which she admitted being given, and the policy guide. The law is right that in claim for wrongful termination of employment, the onus is on the claimant to put forward the letter of employment containing the terms and conditions of contractual arrangement. On the other hand, the claimant may put forward his contract of service, which must also contain the contractual terms and conditions agreed to be by the parties or by the employer and the employee. It is therefore incumbent upon the claimant to prove to the court the terms and conditions of his employment, of her employment, the manner how her employment may be terminated, and how the employer has failed to comply with the manner for termination as contained in either the letter of employment or the contract of service. See the case of Emokpai versus University of Benin. See also University of Calabar versus Asian. See also Organ and others versus Nigeria Liquefied Natural Gas and another. I must reiterate here that the importance of terms and conditions of service cannot be overemphasized, as the court have stated and restated time without numbers that the terms and conditions of service of staff or staff handbook is what the whole contract of service is all about. The reason is not far-fetched, as it is determining factor for the rights and obligation of the parties to the contract of service. The law is also settled that terms and conditions of service may be contained in many documents, in which case where there is dispute regarding the contract of employment, the court is bound to examine all the series of documents forming the terms and conditions of service for any just decision to be made regarding the employment. In the case at hand, the terms and conditions of service are the letter of employment and the policy guide of the first defendant. The claimant has refused to tender her letter of employment, which forms part of the terms and the terms and conditions of service. It should be noted that in law, the defendant had no responsibility or duty to establish the terms and conditions of service. The claimant, having failed to produce the letter of employment, has failed in her duties in proving the terms and conditions of her employment. However, letter of employment is only one document and the policy is another document. But the claimant has stated, but the claimant has stated, which the defendant supports, that she was never given the policy. So how does the defendant want the claimant to know the terms and conditions as encapsulated in the policy guide when the defendant has even stated that it is bulky document? It is clear from the foregoing that both the claimant and the defendants have their own share of blame regarding the non-production of the complete terms and conditions of service. In the circumstances, considering the grievances of the claimant without tendering the letter of employment and the entire guide, there is no way the court will do justice to the case by restricting its consideration on the partial condition of service, partial conditions of service tendered before the court. Also, what the defendant has tendered is not the entire policy document, but is part of a whole. Since the claimant contract of service is that of master and servant relationship, I am left with no option than to resort to the labor law, common law, and the general labor law and the general common law in determining the questions posed by this suit for resolution. A master and servant relationship, that is to say master, employer and employee, the employer has always has an unfettered right to do away with the service of his servant or employee, provided the employee was accorded fair hearing. In the case at hand, claimant was accused of misconduct. He was invited to attend or to appear before the disciplinary committee hearing of the defendants. At the end, she honored the invitation, and at the end, she was found guilty as charged, and her employment was recommended for termination. The claimant appealed against the verdict of the disciplinary committee, and the verdict was upheld by the appeal panel. In this case, we are not concerned with whether the claimant was guilty as charged or not. what this court is concerned with is whether the claimant was given opportunity of knowing the accusation against her and whether she was given opportunity to defend herself. From the evidence before me, the disciplinary committee has accused the claimant, has accorded the claimant fair hearing. However, the appeal panel cannot be said to be unbiased in view of the presence of the second defendant who chaired the disciplinary panel as an observer at the panel. This has tainted the appeal hearing with bias. The claimant cannot, in the circumstances, be said to be given fair hearing at the appeal, more particularly when the entire procedure for discipline has included the appeal process. The presence of the second defendant at the appeal hearing has also gone to show that the entire disciplinary hearing conducted by the second defendant was prejudicial to the claimant in that wise, the claimant cannot be said to have been treated fairly by the disciplinary committee hearing and the appeal hearing, since these two procedures were agreed by the parties to be part and parcel of the entire disciplinary procedure of the first defendant. The termination of the claimant's appointment cannot be said to have followed due process. In the circumstances, I found termination of the claimant's employment to be wrongful. The claimant has strenuously argued that the court has strenuously urged the court to found that her fundamental rights as enshrined in section 34 and 45 of the Constitution of the Federal Republic of Nigeria as amended have been breached by the defendant. There is no concrete cogent evidence adduced by the claimant to establish her assertion on violation of her fundamental right, apart from her ipse dixit evidence. The witness who could have assisted the claimant is one Idioma was not called as witness. This means all the evidence given regarding the purported hatching of plan to remove the claimant from service by all means orchestrated by the second defendant was not proved as evidence that could have established such allegation amount to hearsay. The claimant in her claim has sought for an order that her contract of employment still exists despite being terminated because according to her, the termination was wrongful. The law is that in master and servant relationship where the contract has no statutory flavor or being backed up by statute, once termination is effected, it has effectively ended the relationship. It has effectively ended the relationship and an employee cannot treat his employment as subsisting. The law regards employee whose appointment is terminated or is dismissed cannot reject such step taken by his employer and regard his employment as still subsisting. See the case of Waek versus Oshenibo. It is also the law that even if the termination of the contract of service by an employee is in breach of contract, the remedy for the employer is not a specific performance of the contract, but rather for damages for breach, where a termination of contract of employment is not in compliance with the terms and conditions of service, it is wrongful, but certainly not null and void. In such circumstances, the remedy available is in damages. The rationale behind this principle seems to stem from another principle that the court will not foist on unwilling employer a willing employee. See Adebayo versus Sunday Joseph and others versus Kwara State Polytechnic and others. The law is also tried that a servant whose employment has been terminated cannot claim for salary for the period of no longer in employment. See the case of Supreme Bank versus Babatunde. See also Obot versus CBN where the apex court stated clearly that an employee dismissed in breach of his contract of employment cannot choose to treat the contract as subsisting, and the claim for salaries and entitlement he would have earned up to the end of the contractual period. An employee can also not claim salaries from the date of termination to date of judgment. The reason being that no service has been rendered, as the employee cannot in law claim what he has not worked for. The last question that needs to be settled is, since the termination of claimant's employment has been found to be wrongful, then what measure of damages the claimant will be entitled to. The law has been settled that where court found termination to be wrongful, all that the claimant is entitled to is salary for the period of notice of termination. In a claim for wrongful termination, the measure of damages is prima facie the amount that the claimant would have earned had the employment continued according to the contract. See the case of Western Nigerian Development Corporation versus Jimo Abimbola. See also Nigerian Produce Marketing Board versus Adewumi. See also Africa Newspapers versus Jacob Akano. In contract of employment, the amount of damages due to an employee where employment has been wrongfully terminated is award of salary for the period of notice and other legitimate entitlement at the time the employment was determined by his employer. See the case of Gabriel Atibi versus Kabel Metal Nigeria Limited. See also Imolome versus Wayek. As pointed out earlier, in this judgment, the terms and conditions of service were not made available to the court for the court to find out what length of notice the claimant is entitled to in order to determine the amount of money the claimant will be entitled to. In the circumstances, resort will be had to the labor law, section 11, subsection 3, since the claimant has served for over 3 years, is entitled to 1 month's salary in lieu of notice. This means since notice has not been given, she is entitled to payment of 1 month notice in lieu of 1 month salary in lieu of notice. The claimant, by her admission, has admitted receipt of 1 month salary in lieu of notice. This has taken care of the damages the claimant is entitled to under this judgment. On solicitor's fees, this court has taken the position that a claimant cannot incorporate claim for solicitor's fees in the claim regarding employment, as that is not part of the course of action. Therefore, the claim for solicitor's fees failed and is also refused. On the whole, the claimant succeed in terms of declaring termination of her employment to be wrongful, and she is entitled to payment of 1 month salary in lieu of notice of termination. And the claimant had been collected the said 1 month salary in lieu of notice through her account, which she acknowledged and admitted under cross-examination before the court. The claimant has collected her entitlement, and there is no any outstanding entitlement with the defendant. In view of the foregoing, the claimant only succeeded in having termination of her employment to be declared wrongful, and the remedy for such wrongful termination has been complied with by the defendant by paying the claimant 1 month salary in lieu of notice. I make no order as to courts, parties to bear their respective courts, judgment entered accordingly.
As the court pleases.
Yes.
My lord.
Yes.
We want to thank the Honorable Court for the well-researched and intellectual judgment. My lord, right. We also want to thank the Honorable Court for the industry that the Honorable Court has put into this matter as a whole. My lord, I have been doing matters in other courts, but I can say that my Lord has reaffirmed the passion for justice, administration of justice, my Lord, sir, because this matter was concluded just in a bit of, if not for a few issues, we would have concluded in a bit of a year. And this is very novel, sir. I'm very grateful, and I pray that the Lord will continue to grant me, Lord, wisdom and understanding, sir. I'm grateful, sir.
Amen. You are welcome.
Yes, sir.
Yes, okay, Council. Thank you very much. We have come to the end of the virtual sitting. The administrator, you can end the sitting.